Hannah Mackey, hearing with and on behalf of Charles McLaughlin.
All right, very good.
Andrew Childers appearing on behalf of the people, Your Honor.
All right. And this is a continuation of a preliminary examination, which I believe, I think it was Detective Rob was on a call that day.
That's correct.
Now he's here. And so you may call your next one.
Thank you, Your Honor. People would call Thomas Robb to the stand.
All right. Sir, please come forward to be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth? I am. State, spell your first and last name for the record.
Thomas Robb, R-A-B.
Sir, thank you, Your Honor. Sir, how are you currently employed?
I've been with Washington County Sheriff's Office.
And how long have you worked with the Sheriff's Office?
4 years.
Were you working in that capacity back on April the 5th this year, 2025?
I've been licensed as a road patrol deputy.
Road Patrol Deputy? Thank you. Directing your attention to around 7:30, 7:45 in the morning, were you in the vicinity of the West Willow neighborhood?
I was.
Okay. And on that date and time, what was your shift?
Sorry.
What was your shift that day?
I was working day shift.
Okay. What time did you start?
8 a.m.
8 a.m. Okay.
I believe the 7:30 time was when the call initially came in.
Okay. At some point, as your shift started, were you made aware of an investigation regarding a possible stolen Ford Explorer?
I was.
Okay. And who made you aware of that?
Deputy Phillips.
Okay. And what, if anything, happened in that morning on April the 15th that led to you being involved with that Ford Explorer in any way?
Deputy Phillips told me that he'd taken a stolen vehicle report for that vehicle. He advised that he had obtained GPS location for the vehicle from the victim. That it was pinging, I believe, on Brookside, which was in the West Willow neighborhood. He advised that he was going to go check the area for the vehicle and asked me to assist.
Okay. Were you and Deputy Phillips in the same patrol vehicle or separate patrol vehicles?
Separate.
Okay. To your knowledge, did Deputy Phillips arrive in the area of that suspected stolen vehicle before or after you?
Before.
Okay. How did you know that?
I heard him call it on the radio.
Okay. When you heard him call that out, where were you?
A few blocks away.
Okay. And what happened next?
After he called out that he was out with the vehicle, again, I believe it was on Brookside. I was a few blocks away. I heard mic clicks on the radio. That's pretty much when somebody depresses the talk button on the radio, but doesn't have a chance to get a transmission out. In my 7 years of doing this job, normally when I hear that, that tells me that the deputy's in trouble. There's some kind of accident that caused them to interrupt their transmission, whether they're chasing someone or fighting or something of that nature. So that gave me cause for concern. I continued towards that location where Deputy Phillips was at, and then I saw the, I believe it was 2024 gray Ford Explorer. That was the vehicle in question. Speaking of the neighborhood.
So as you're entering the neighborhood, it's exiting the neighborhood?
Correct.
Okay. And what did you do next?
I recognized that it was the vehicle we were looking for. I believe Deputy Phillips was in danger or something had happened, so I activated my emergency lights and siren to try to stop the vehicle.
Okay. And did you have to turn your vehicle around?
No, I was coming right at the entrance to the...
What started as a stolen vehicle investigation had now become something much more dangerous. Deputy Robb believed another officer might already be in trouble after hearing an interrupted radio transmission. Moments later, he spotted the stolen Ford Explorer leaving the neighborhood, setting off a pursuit that prosecutors would later describe as one of the most critical moments in this entire case.
Did the vehicle pull over after you activated your overhead equipment?
No.
Okay. What happened next?
The vehicle accelerated and tried to evade me.
And did you continue to pursue the vehicle?
I did.
And for how long did you continue to pursue this vehicle before it was eventually stopped?
I believe about 10 minutes or so. I don't recall exactly the time.
Okay. Where during that time, do you know, Detective Robb, what speeds did you get to?
I believe maximum speed was about 130 miles an hour.
130?
Yes.
Okay. What sort of vehicle were you in?
A Ford Explorer.
Okay.
It was a fully marked patrol car.
Thank you. At At what point did this chase terminate in any way?
Van Buren police assisted us with the pursuit. It was a Van Buren officer deployed stop sticks, which the stolen vehicle ran over, which caused, I don't know if it was one or multiple tires to deflate, and then the vehicle crashed into a berm at the entrance to a neighborhood. I believe it was on the end of any forest roads.
And that's in Van Buren Township?
I believe so.
Okay. From the time period that you started this pursuit in the West Willow neighborhood to the time that it ended in Van Buren Township, did you ever lose sight of this Ford Explorer?
No.
Okay. After the vehicle was hit the stop sticks and crashed into the ditch, were you able to determine if the vehicle was occupied?
Yes, I was.
And were you able to see anyone in that vehicle?
Yes.
Okay. Are any of the individuals that you saw in that vehicle on April the 15th in the courtroom here today?
Yes.
Can you identify an article of clothing that they're wearing?
Yes, it was Charles McLaughlin. He's sitting to my left wearing a green jumpsuit.
And where, Your Honor, may the record reflect in court identification of the defendant?
Without objection, record shows so reflect.
And where in the vehicle did you observe the defendant?
He was exiting the driver's seat.
Okay. Was there anyone else in the vehicle?
No.
And what did you do at that point when you made contact with the defendant in the driver's seat of this vehicle?
He was exiting the driver's seat. I told him to show me his hands and get on the ground. He did. I placed him in handcuffs.
Okay. Did he appear to be injured in any way?
I believe he had some scrapes or bruising on his arms. Maybe, I think he might have had a small amount of blood on his lower lip, if I recall.
Okay. Is it, do you recall, did like the airbags deploy in this crash?
I don't recall.
Okay. I have no further questions, sir. Thank you.
All right. Thank you. Cross-examination.
Good afternoon, Deputy Rob. You were in pursuit of the vehicle in question,
Yes.
and you followed that vehicle for around 10 to 15 minutes. And during that time prior to the accident, you got no closer than 50 feet, did you?
I got no closer
To
than,
the vehicle than 50 feet, would you say?
I don't know how close I got during the pursuit. I guess 50 feet might be accurate about closest I was, but I don't recall without reviewing the camera footage.
And you testified on direct that during the course of the pursuit, you activated your sirens. Is that correct?
Yes.
And at some point you were driving on the highway.
Yes.
Was it a busy highway?
I would say there was a medium amount of traffic.
So that means that there were other cars on the highway during the pursuit.
Yes.
And you had to make several lane changes to navigate through that traffic, didn't you?
Yes.
And some of those cars pulled to the side. Is that correct?
I'm sure some of them did. Well, usually people play not very good about pulling over.
And it would be safe to say then that some cars did not pull to the side. And at one point you had to even drive on the shoulder of the freeway. Is that correct?
Yes.
You don't know why some of the people did not pull over to the side, do you?
Well, without talking to them personally, no, I wouldn't know why.
So you don't have any personal knowledge then as to whether or not the drivers of the vehicles could hear the sirens.
I suppose so. Yeah, without talking to them.
So then it would be fair to say that you didn't know why those vehicles did not pull over.
I guess so.
And you don't have any personal knowledge that Mr. McLaughlin could or could not hear the sirens, did you?
I suppose not.
Thank you, Your Honor. No further questions.
All right. Can you redirect?
No, Your Honor. Thank you so much.
Sir, thank you.
Thank you. Your Honor, I'll start with the assault with intent to murder. So looking at the jury instruction 17 and Michigan pattern criminal jury instruction 17.3, assault with intent to murder requires the defendant try to physically injure another person. Second, that when the defendant...
The chase may have ended with an arrest, but inside the courtroom, the biggest battle was only beginning. The judge wasn't deciding guilt or innocence today. Instead, the court had to answer a crucial legal question. Was there enough evidence for a jury to consider attempted murder, or was this simply a desperate attempt to escape?
Appeals published case 288 Mishap 192. This is from 2010. Specifically states this points to this jury instruction as the elements of assault with intent to commit murder. It is not assault with intent to commit first-degree murder. It's just assault with intent to commit murder.
So I don't even need to address that issue, whether there's an exception
There's nothing in the jury instruction
that requires. Okay.
And so then we're left with the question of is the defendant in driving a Ford Explorer at Deputy Phillips intending, can you infer from that behavior an intent to kill? And the argument before the court that the people would put forth is when you're piloting what is probably a 4,500 or 5,000 pound object, accelerating and pointing that vehicle at an individual, you absolutely, that those actions, there is a logical inference that can be argued that would create a question of fact that you're intending to kill that person. That's a mass, we're not talking about a motorcycle or a scooter or a golf cart or anything else. We're talking about a Ford Explorer. This is a large vehicle. The defendant looked, based on the testimony of Deputy Phillips, he was looking right at him. Deputy Phillips is attempting to get him stopped. He steers in the direction of Deputy Phillips, hits the gas, and hits him. Now, granted, Deputy Phillips was able to get out of the way, and it only struck his knee and kind of fell to the ground. But we have to consider the actions of the defendant, and I think to a probable cause standard, there is certainly a question of fact as to the defendant's intent. But unequivocally, if you take a Ford Explorer and you floor it and you aim it at someone, you can kill them. That is just common sense. Regarding the UDAA, again, relying on the jury instructions, unlawful driving way out of automobile requires first that the vehicle belonged to someone else. Second, that the defendant took possession of the vehicle and drove it away. And third, that these acts were both done without authority or without the owner's permission. Fourth, the defendant intended to take the vehicle without authority, knowing that he or she did not have the authority to take the vehicle and drive it away. As the court alluded to, that doesn't require that you must take the vehicle from the first place it was stolen. Now, I think that there's a logical argument and facts such that the location of the hotel versus the location of where this vehicle was found and the time frame that it happened at some point overnight, and this is 7:30, 8 o'clock in the morning. Again, there's a logical inference, circumstantial evidence to suggest that the defendant did in fact take that vehicle from the hotel parking lot. We're not talking about one state over or 200 miles away, something to that effect. But I believe that, again, there is sufficient evidence before this court to a probable cause standard that there is a question of fact regarding that count. And I believe that the defendant should be bound over on all 5 counts.
All right, thank you. With reference to, there is no dispute as to a bind over on count 2, 3, and 5. Therefore, the court also does believe that the people have sustained their burden, and
everything now came down to the judge's interpretation of the law. The defense insisted there was no proof of an intent to kill, while prosecutors argued that driving a speeding SUV directly toward a deputy spoke for itself. The ruling that followed would determine whether the defendant faced trial on every major charge, including attempted murder.
Certainly a jury could reasonably infer from the hotel, the timing, and everything else that it was indeed the defendant to do that. I don't think that people have to go beyond that. So certainly under that, if the theory is correct that it's got to be taken from the location from the owner, but I don't think that that's correct. But still, even then, I think a reasonable fact finder could conclude that. As it relates to the other piece of that, I think an individual can be charged with the unlawful driving away of a motor vehicle when they took possession or assisted in taking possession of that vehicle. I don't think it excludes, it doesn't get charged or can't be found to the exclusion of something else, a receipt and concealment. Certainly a reasonable fact finder could conclude that the defendant did, even at that location, take and or assist in the taking of that vehicle and its unlawful driving away. So that charge would be proper, and a fact finder could conclude that. So the court would bind the defendant over for those reasons on count 4. With reference to count 1, the assault with intent to murder, I also do not believe that it requires first-degree murder and some premeditation within that. It is really the intent to kill, as the instruction indicates. But even though I do believe that if it were to require that, I think that premeditation is implied within the actions of the defendant because of what was happening, and there's no equal protection.
Thanks for subscribe my channel.